I was proud that we crossed party lines to certify one of the most secure elections in our history. And when Republicans and Democrats came together again days later for the inauguration of President Biden, America sent a powerful message to the world. Neither a deadly pandemic nor a violent insurrection can defeat our American system of self-government. Now, that was just 90 days ago. But instead of capitalizing on measures that resulted in the highest voter turnout in over a century, dozens of states have moved forward to restrict access to the ballot. As of March, more than 360 bills have been introduced in state legislatures to make voting harder for Americans. These cynical efforts have been justified on the grounds it should be harder to cheat, which, of course, falsely implies that voter fraud was a widespread problem. Did we not just go through an election where there was virtually no evidence of voter fraud and it was looked at by the courts and that's the conclusion they came to? Did we not just reject a violent attempt to overturn our election based on the utterly false claim that was stolen through fraud? Now, I realize memories may be short, but this wave of voter suppression laws is premised on a little bit more than the big lie with a slapdash paint job. If you rejected the big lie then, you should oppose these efforts today. We should all easily agree that when any voters in any party are disenfranchised, our democracy suffers. Depriving Americans of the foundational right to vote also denies them representation in our democratic republic. It's exactly why the 1965 Voting Rights Act, which helps the federal government prevent voter disenfranchisement, has been bipartisan. Every Congress, from 1965 to 2006, repeatedly reauthorized the Voting Rights Act on a bipartisan basis, including in our body, Mr. Chairman, in 2006, by a vote of 98-0. Now, among those who joined me in voting yes in 2006 were Ranking Members Grassley, Senator Graham, Senator Cornyn. The reason the Voting Rights Act has always been a bipartisan bill is it's pro-democracy, not pro-Republican or pro-Democrat. So I hope there will be increased support for the already bipartisan John Lewis Voting Rights Advancement Act. It just restores the federal government's powers under the Voting Rights Act. Without Section 5 powers, which my dear and close friend John Lewis, a hero to many, called the heart and soul of the Voting Rights Act, no administration of either party has the necessary tools to prevent states from enacting changes making voting more difficult for Americans. And as we watch almost daily, states unleash a wave of ill-founded laws that restrict the precious right to vote, not protect it, but restrict it. The oversight role of the federal government envisioned by the 1965 Voting Rights Act is more urgently needed than ever. All of us, Republicans and Democrats, should remember what we saw and how we felt on January 6th. We should all recall casting our votes in the twilight hours of January 7th in our capital, the seat of our government that bore the fresh wounds of a violent attack that sought to deny the American people's will. And that day, we put aside our partisan differences in defense of something much bigger than political party, our democracy itself. In the months ahead, Mr. Chairman, I hope we can answer that same call to defend our sacred right to vote, the right that gives democracy its name. Thank you.
Thank you, Senator Leahy. Senator Cornyn.
Thank you, Senator Durbin and Senator Grassley, for holding this important hearing today. This is an important topic, but I don't think we do justice to this topic by entitling this Jim Crow 2021. Unfortunately, rather than the usual oversight and fact-finding and legislating process, it looks like today's hearing is really just performance art in order to enhance a false narrative about how far we've come in this country, thank goodness, when it comes to minority voting rights participation. The right to cast a ballot, of course, is the cornerstone of our democracy. It's the process through which the will of the people is heard and turned into action. The very basis for the legitimacy of our laws is the consent of the governed, and they consent by electing their public officials at the ballot box. I believe our standard should be that we should make it easier to vote legally in America, but also at the same time make it harder to vote illegally. Well, sadly, the right to vote was denied to a generation of Americans based solely on their gender or race. This type of discrimination stands in stark contrast to the founding principles of our country. And I hope I can speak on behalf of everyone in this room when I say we need more Americans to participate in our democracy, not fewer. In Texas in 2020, we had a historic turnout of registered voters, 66% of registered voters of all ethnicities and race. Just as Americans have a right to make their voices heard in our elections, Congress has a responsibility to make sure those elections are fair and free. If we don't have fair and free elections, we don't preserve the core constitutional right of the people to make their voices heard through the ballot box. Expanding voter access does not have to come at the expense of common sense guardrails and protections that preserve the integrity of the ballot. For every one person who votes who is unauthorized or is disqualified to vote, that dilutes the vote of legitimate and legal voters. And disparaging those same common sense protections like voter identification as Jim Crow 2021, or in other words, racist, is false and I believe dangerously so. Our founders understood that all power ultimately resides in the hands of the people. When government takes its power away from state legislators, it is effectively seizing power from the people of those states to hold their elected officials responsible. This is very important because our founders gave us a roadmap, in other words, the Constitution, as to the power residing in the hands of the people through their ability to hold their state legislators accountable. Article 1, Section 4 explicitly gives the states the power to regulate, quote, the times, places, and manner of holding elections, close quote. Congress may, however, quote, at any time make or alter such regulations except as to the place of choosing senators. I read this to mean that the states are to chart their own course for elections, subject to guardrails, and where necessary, Congress can provide additional guidance, but cannot hijack the process entirely. Nowhere in the Constitution does it empower the federal government to completely usurp the role of the states in holding elections. Indeed, nowhere does the Congress have the authority in one of its enumerated powers, as reflected in Article 1, Section 8 of the Constitution. In a recent gerrymandering case, Chief Justice Roberts noted that the framers assigned the issue to the state legislatures, expressly checked and balanced by the federal Congress. Yet through H.R. 1, Congress is not acting as a check. It's acting like a hijacker to take over the constitutional authority from the states and acting as the sole arbiter as how an election is run in rural Vermont or downtown Chicago. This past election, for example, we had the highest turnout ever in a presidential election. According to network exit polls, the number or percentage of African Americans who cast their ballot is roughly the same as the percentage of the African American population in America. I'm encouraged by this trend of more people voting and hope it continues. I agree we should have this hearing and we should look at appropriate bipartisan solutions to improve voter access. But using charged rhetoric to describe aspects of state voting laws like the one in Georgia is misleading. It's not constructive, and it undermines public trust in Congress and in our election system. In fact, as we've learned, the Georgia law comports with the existing laws of many Democrat-run states and also reflects the safeguards supported by the bipartisan Carter-Baker Commission. This is not to say that there's not more work to be done, but it is important that we temper the charged rhetoric and understand the specifics that we're actually talking about, rather than jumping headfirst into this debate across the country in a rush to judgment. Here's just one example. The Georgia provision requires a free ID card in order to receive an absentee ballot. That's nearly identical to the provision in the 2002 bipartisan bill supported by then Senator Biden and the current chairman of this committee. Indeed, the Help America Vote Act would have required everyone voting in a federal election to provide a copy of a photo ID. And if they don't have one, they can get one or provide a copy of the bank statement, paycheck, government document, or utility bill. In other words, they can do it for free. I don't think this is a radical proposition to suggest that voting identification coupled with the offering of free ID cards is a radical restriction on voting. It just doesn't hold up. To the contrary, it's a basic safeguard to preserve the right of people to vote and for their vote to count equally in a free and fair election. And this safeguard helps inspire public confidence at the same time. The Carter-Baker Commission, Jimmy Carter, James Baker III, named for them, looked at preserving the integrity of our elections, and they reached the same conclusion. The electoral system cannot inspire public confidence if no safeguards exist to deter or detect fraud or to confirm the identity of voters. Photo IDs are currently needed to board an airplane, to enter a federal building like this one, to operate a motor vehicle, to cash a check, to buy alcohol, and pick up will call tickets at the Major League Baseball games. I support efforts to expand voter access, but these efforts cannot interfere with the integrity of our elections. Today's hearing is an excellent opportunity to discuss that and expanding access to the ballot box for all eligible voters. I appreciate the chairman and ranking member holding this hearing. Not so much the title of the hearing, but I do think the subject matter is important, and I'm eager to hear more from today's distinguished witnesses.
Thanks, Senator Cornyn. Today we welcome two members of Congress to testify, Senator Reverend Raphael Warnock of Georgia and Congressman Burgess Owens of the 4th District of Utah. In addition to representing the state of Georgia after his election earlier this year, Senator Warnock serves as senior pastor of the historic Ebenezer Baptist Church in Atlanta, where our late colleague, Congressman John Lewis, was a member. Senator Warnock, could you please proceed with your statement?
Thank you, Chairman Durbin and Ranking Member Grassley and members of the committee for inviting me here today. I'm especially glad to join these distinguished witnesses. Mr. Chairman, I've come here today to stress the critical need for the federal government to act urgently to protect the sacred right to vote. America is a land where possibility is born of democracy. Our vote is our voice, a chance to help determine the direction of our country and our own destiny within it. Record numbers of Georgians used their voices and voted in the last election. And in response to this swell in Democratic participation, politicians in our state legislature responded not in celebration, but with retaliation. They could have gotten busy having not seen the outcome that some of them wanted. They could have gotten busy changing their message or adjusting their policy. Instead, they got busy changing the rules as if the democracy belongs to them and not the people. We've seen voter suppression bills since the election in November and January all across this country. 360 voter suppression bills in 47 states, an increase of 100 bills since I highlighted this issue on the Senate floor just a month ago. As of today, 5 of these bills, including in my own state of Georgia, have been signed into law. These efforts vary in exactly how they suppress voting. Some new laws, like in Georgia, will make it harder to vote by mail. Some will make lines that are already too long longer. Harder to cast a provisional vote. The new law also gives state politicians, some of the same politicians who still today refuse to acknowledge President Biden's lawful and decisive victory, the power to override local election officials. We may be tempted to dissect these bills as if analyzing them piece by piece makes them more rational. But that narrow analysis only obscures the larger, unmistakable picture. This is a full-fledged assault on voting rights, unlike anything we have seen since the era of Jim Crow. For all of their differences in exactly how they suppress the vote, what these bills all share is that they are predicated on the big lie, that the outcome of our last elections were the result of fraud, or at least the presidential election. I guess the members who won their elections are okay with that outcome. The truth is, politicians in their craven lust for power are willing to sacrifice our democracy by using the big lie as a pretext for their true aim. Some people don't want some people to vote. To be sure, we have seen these kinds of voter suppression tactics before, aimed at the same communities. They are a part of a long and shameful history in Georgia and throughout our nation. But that history is also filled with moments of hope and promise, when our nation has come together in recognition that preserving our democracy is absolutely essential. Voting rights are preservative of all other rights. Just 15 years ago, the United States Congress reauthorized the Voting Rights Act of 1965 under a Republican president, and with a bipartisan vote in the Senate of 98-0. At the time, our colleague, Senator Mitch McConnell, praised its passage, declaring it a law that would make a difference for all of America. Many members of this committee, including the chair and the ranking member, enthusiastically voted in favor of it. That was 2006. Why shouldn't voting rights legislation be just as bipartisan now in 2021 as it was in 2006? Voting rights should always be bipartisan. It is not the difference between right and left, but the difference between right and wrong. Many argue that the United States Senate is dysfunctional and incapable of governing in a bipartisan manner. We can boldly refute these claims by coming together not as Democrats or Republicans, but as supporters of democracy itself to pass the For the People Act and the John Lewis Voting Rights Advancement Act. Together, these two bills would turn the tide against state-level voter suppression proposals all across our country. These pieces of legislation would expand and protect access to the ballot for every citizen, Democrats, Republicans, and independents, because strengthening our democracy does not benefit one party over another. Instead, democracy reform benefits all of us by ensuring that our government is of the people, by the people, and for the people. John Lewis was my parishioner. I was honored on many occasions to stand with him as we took people to vote after church at Ebenezer. He understood that our democracy transcends all else, and he nearly died on the Edmund Pettus Bridge defending it. Today, our country faces the most widespread assault on voting rights since that era. The four most powerful words in a democracy are "the people have spoken." The highest and most sacred action that the Senate can take is to protect the right of the people like it did in 1965. As we move forward in this discussion, I've asked myself on many occasions, what would have happened had we not passed federal legislation affirming the covenant of our democracy in 1965? Where would Georgia be? How would it prosper on the other side of a segregationist curtain. If we had not acted in 1965, what would our country look like? Surely I would not be sitting here, only the 11th black senator in the history of our country and the first black senator in Georgia. And maybe that's the point. It concerns me that some don't hear the irony in their statement that we must protect minority rights in the Senate while refusing to protect minority rights in the society. We've got to act. History is watching us. Our children are counting on us, and we must pass federal voting rights legislation no matter what.
Thank you, Senator Warnock. Senator Grassley, would you please introduce your guest?
It's a great pleasure to introduce him, and most people probably know him better as an outstanding NFL football player, but it's my pleasure to introduce Congressman Burgess Owens. Congressman Owens represents the great state of Utah, along with our colleagues, Senator Mike Lee and Romney. Congressman Owens is a new addition to the House, and we're so pleased to have him here with us this morning.
Thank you, Chairman Durbin, Ranking Member Grassley, and the members of the committee for the invitation to join you today at this hearing. My American story begins with my great-great-grandfather, Silas Burgess, who arrived in America as a child, shackled in the belly of a slave ship. Silas was sold on an auction block with his mother in Charleston, South Carolina, to the Burgess plantation. He escaped through the Underground Railroad and later became a successful entrepreneur, purchasing 102 acres of farmland paid off in 2 years. My grandfather, Oscar Kirby, served our country in World War I and was a respected and successful farmer, raising 12 children, all of them graduating from college. My father, Clarence Burgess Owens Sr., was stationed in the Philippines at the end of World War II. When he returned home to Texas, actual Jim Crow laws denied him a postgraduate education. Raised in a generation that used this as motivation, he received his PhD in agronomy at Ohio State University and had a successful career as professor, researcher, and entrepreneur. I grew up in the era of actual legalized institutional racism. I grew up in the Deep South in Tallahassee, Florida, in the 1960s during the days of KKK, Jim Crow, and segregation. My first experience with white Americans was at 16 years old. At 18, I was the third black athlete to receive a scholarship to play football at the University of Miami. Now I proudly represent Utah's 4th Congressional District in the U.S. Congress. I sit today before you as someone who's lived the American dream, as have millions of other Americans of all races from every background. This is due to our country's mission statement that all men and women are created equal. A mission statement that every American should have the equal opportunity for life, liberty, and the pursuit of happiness. But as someone who's actually experienced Jim Crow laws, I'd like to set the record straight on the myth regarding the recently passed Georgia state law, and why any comparison between this law and Jim Crow is absolutely outrageous. Here are a few examples of my own life of what Jim Crow laws actually look like. At the age of 12, my father allowed me to participate in a demonstration with college students in front of the segregated Florida State Theater, where because of our color, we could not enter. I was the youngest participant there. Only 50 years later did I learn that my father had parked across the street to watch and make sure I was safe. In the 7th grade, my school never received new books. Instead, we received books from the all-white school across town. At service stations, there were white men-only restrooms, white women-only restrooms, and a filthy restroom in the back of the station for black Americans designated as colored. In addition, Jim Crow laws like poll tax, property tests, literacy tests, and violence and intimidation at the polls made it nearly impossible for black Americans to vote. The section of the Georgia law that has brought so much outrage from the left simply requires any person applying for absentee ballot to include evidence of a government-issued ID on their application. If a voter does not have a driver's license or ID card, that voter can use a current utility bill, bank statement, government check, paycheck, or any other government document that shows a name and address of this voter. If a voter somehow cannot produce one of these above forms of ID, that voter can still vote and cast a vote, provisional ballot. By the way, 97% of Georgia voters already have a government-issued ID. What I find extremely offensive is the narrative from the left that black people are not smart enough, not educated enough, not desirous enough for education to do what every other culture and race does in this country: get an ID. True racism is this. It's projection of the Democratic Party on my proud race. It's called the soft bigotry of low expectation. President Biden said of the Georgia law, this is Jim Crow on steroids. With all due respect, Mr. President, you know better. It is disgusting and offensive to compare the actual voter suppression and violence of that era that we grew up in with a state law that only asked that people show their ID. This is the type of fear-mongering I expect in the 1960s, not today. And by the way, literacy tests and poll tests were initiated by the Democratic Party. The intimidation of black Americans by the KKK was initiated by the Democratic Party. Jim Crow, that I grew up in the South, of segregation, was initiated by the Democratic Party. The soft bigotry of low expectation now projected on black Americans, not Italians, not Asians, not Polish, not Jewish, but only black Americans, is being done by the Democratic Party. Where black misery today thrives and is prevalent, lack of education, lack of jobs, high crimes, the call for defund the police is all done in Democratic parties. By increasing illegal votes and not giving voice to those legal Americans, black Americans, who are seeing and waking up today is the real tragedy of this process. We're seeing 18% of black men turn away from the Democratic Party because they're seeing that their vote can count and their future can matter. We're seeing twice the percentage of black women doing the same. A record number of Hispanics, Asians, and gay community members doing the same. So no, all Americans expect, very simply, is fairness, security, to walk away from the poll booth knowing that my vote counted. If we didn't win, we work harder next time to make sure our message resonates. But to call this Jim Crow 2021 is an insult, my friends. For those who never lived Jim Crow, we are not in Jim Crow. And for black Americans to go out every single day and vote the way we feel we should is a right that we should have, and not being demeaned by something 60 years ago in which we had no right to do any of the above. Thank you very much.
We will now turn to our panel of witnesses. We thank the members for attending. Today, we welcome 5 witnesses to testify about the latest assault on the fundamental right to vote. I will introduce the majority witnesses, then I'll ask Senator Grassley to do the same for the minority witnesses. Our first witness is Professor Carol Anderson. She's the Charles Howard Candler Professor of African American Studies and Chair of African American Studies at Emory University in Atlanta. Professor Anderson's research focuses on public policy and the intersection of race, justice, and equality in the United States. She's the author of multiple books, including White Rage, The Unspoken Truth of Our Racial Divide, and One Person, No Vote, How Voter Suppression is Destroying Our Democracy. Sherilyn Ifill is well known to the committee and others. She's the president, director, counsel of the NAACP Legal Defense and Education Fund, a civil rights organization founded by Thurgood Marshall in 1940 that has led some of the most significant legal battles for racial justice and equality. She first joined LDF in 1988 and took over as director counselor in 2013. Finally, the Honorable Stacey Abrams, joining us from Atlanta. She served for 11 years in the Georgia House of Representatives, including 7 years as Democratic leader. In 2018, she became the first black woman to be the gubernatorial nominee for the major party in the United States. After witnessing the voter suppression efforts during the 2018 election, she launched Fair Fight and Fair Fight Action to protect the voting rights of Georgians and other Americans. Ranking Member Grassley, would you please introduce your witnesses?
Yes, I'm going to introduce Speaker Pro Tem Jan Jones, and then Senator Cotton is going to introduce Secretary Gardner. So it's my pleasure to introduce Ms. Jones. In her nearly 20 years in office, Speaker Jones has distinguished herself as an advocate for changing lives and increasing economic opportunity through improved public education and government that responds to the people. She was elected by her peers to serve as the highest elected woman in the Georgia General Assembly in 2010 after serving as Majority Whip. She has authored various bills involving local control, transparency, and accountability. She has also done much to reform Georgia's K-12 education. Speaker Jones lives in Milton, Georgia, with her husband. She is a graduate of the University of Georgia and has an MBA from Georgia State. She's a businesswoman and a mother of 4. I thank her for appearing today. Senator Cotton.
Thank you, Senator Grassley. I am pleased to introduce New Hampshire Secretary of State Bill Gardner, the longest-serving Secretary of State in the country. Secretary Gardner was first elected to serve the people of New Hampshire in 1976, just 1 year before I was born, and Senator Grassley doesn't even want to know how many years before Senator Ossoff was born. He's been serving for that long because he has been serving the people of New Hampshire so well. I would point out that Secretary Gardner is a Democrat, and of course I'm a Republican. I'm sure there are probably some things we don't agree on, but I invited Secretary Gardner to appear because this is not a partisan issue, or rather it shouldn't be. Free and fair elections administered by our 50 state governments are an American issue. That's what our founders intended, and that's why there is bipartisan opposition to these bills that would federalize our state-based system. Secretary Gardner is well positioned to talk about these problems and how this bill would wreak havoc on our elections, but more fundamentally, he can talk about the real problem, the fact that this legislation is a complete takeover of our federal election system. I want to thank Secretary Gardner for being willing to testify. I would suggest to all of those watching that the longest-serving Secretary of State in America and a Democrat has a lot to say that we should probably listen to before we make radical changes to our state-based election system.
Thank you, Senator Cotton. The procedure will follow today. We will swear in the witnesses, and each witness will then have 5 minutes to provide opening statements. There'll be one round of questions, and each senator will have 5 minutes, and I ask them to please try to stay within their allotted times. I would like to ask all the witnesses, and they are in remote status, to please stand in place to be sworn in. Raise your right hand. Do you affirm that the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? I'm going to assume that all witnesses answered in the affirmative. Thank you all. Professor Anderson, please proceed with your opening statement.
Thank you for this opportunity to speak with you about the history of voting rights. I will focus on 3 key themes that echo powerfully in today's electoral landscape. 1, the target of disfranchisement. 2, the use of race-neutral language to evade the 15th Amendment. And 3, the cloaking of disfranchisement under the banner of election integrity. In 1890, during the rise of Jim Crow, legislator James Big Chief Vardaman bragged that the sole reason the Mississippi legislature revised the state's constitution was to eliminate the Negro from politics. Similarly, Virginia Representative Carter Glass, like so many others, rushed to champion a bill in the legislature that would inevitably cut from the existing electorate 4/5 of the Negro voters in the state. I call it bureaucratic violence because it is designed to attack and undermine African Americans' voting rights and other citizenship rights, while providing an aura of legitimacy that physical violence simply cannot bring. What Vardaman and Glass were advocating was an omnibus disfranchisement program, the Mississippi Plan, which was modified throughout the South and included the poll tax, the literacy test, the grandfather clause, and other barriers to the ballot box. Not surprisingly, Black electoral participation dropped precipitously. In 1880, for example, Black voter turnout was 81% in North Carolina. By 1912, a few years after the state amended its constitution to include the poll tax, the literacy test, and the grandfather clause, Black voter turnout had dropped to just 1%. The states were able to destroy Black voter participation by violating the spirit and the intent of the 15th Amendment while adhering to the letter of the Constitution. They did so by deploying race-neutral language that used the legacies of slavery as a proxy for race. The poll tax, for example, required all voters to pay a fee to cast a ballot. What the poll tax actually did, though, was to prey on the endemic poverty created by centuries of unpaid labor, followed by the post-Civil War Black codes and then sharecropping. The tax seemed innocuous on its surface, But because of the poverty, it amounted to black farm laborers paying in 1900 the equivalent of $239 in 2020 to vote. Similarly, the literacy test, which required a voter to read a section of the Constitution, exploited the consequences of denying education to the enslaved for hundreds of years, and then, after the Civil War, grossly underfunding black schools. The race-neutral ploy worked. The U.S. Supreme Court ruled in the 1898 Williams decision that the poll tax and the literacy test did not violate the 15th Amendment because they applied to everyone who wanted to vote. That decision, of course, ignored that not everyone had to deal with the legacies of having their ancestors enslaved for centuries. The result of the court's blessing of a Jim Crow electorate was that by 1940, only 3% of age-eligible African Americans in the South were registered to vote. These states justified erasing millions of American citizens from the ballot box by claiming they were fighting election fraud and protecting democracy. They knew that wasn't the case. The lie of massive rampant voter fraud is serving the same function today as it did during the rise of Jim Crow. It stokes fear in a segment of the population that democracy is in peril and thus provides cover for laws that target black voters with race-neutral language. In the 21st century, as Indiana implemented the first voter ID law in the nation, Secretary of State Todd Rokita recalled that back in 2001 and 2002, election integrity was a huge issue. There was a fear of votes being stolen, even, he added, if that fear didn't pan out to be true. The fear was still there. In 2021, as Georgia passed SB 202, State Representative Alan Powell admitted that widespread voter fraud wasn't found. It's just in a lot of people's minds that there was. That fictional Loch Ness monster has led Republican legislators in 47 states to propose 361 voter restriction bills to address concerns about supposed voter fraud. If left unchecked, this onslaught of bureaucratic violence will make the Mississippi Plan look tame by comparison. Thank you.
Thank you, Dr. Anderson. Secretary of State Bill Gardner is next.
Thank you, Mr. Chairman, Ranking Member, members of the committee. I appreciate the opportunity to speak to you today about a critically important issue that impacts all of us, the integrity of our elections, a foundation of our free society. While I certainly support efforts of individual states to improve their own elections, the states have long been testing grounds for innovation in enhancing and protecting the most fundamental right of the citizens in this country. That's our right to vote. With that said, I am deeply troubled and concerned about the direction some in Congress would take the states in terms of the conduct of elections. An unjustified federal intrusion into the election process of the individual states will damage voter confidence, diminish the importance of Election Day itself, and ultimately result in lower voter turnout. We only need to look at the history of the National Voter Registration Act of 1993, that was commonly called the Motor Voter Law, to see that federal involvement in the election process does not render the promised results. When the NVRA was enacted by Congress, it was believed that many more United States citizens would be able to vote and thus vote. Millions of dollars were spent by the states to comply with that act. It completely changed the voter registration process in the states. In contrast, New Hampshire maintained an exemption to the NVRA due to having Election Day registration at the polling place. And as a result, saw its voter turnout of voting age population surge to the top tier of voter turnout among the states, and has consistently maintained its position in the top 3 states for the past 4 presidential elections. Since the year 2000, New Hampshire has been double-digit percentage points higher than the national average, again using voting age population. The attached voter turnout charts will illustrate these trends, and be very important to take a close look at those charts. In a one-size-fits-all federal approach, legislation known as For the People Act would trample New Hampshire's state constitution, which requires all votes to be received, counted, and the results publicly announced on the day of the election, and permits absentee ballots to be used only by voters who will be absent on election day or who have a disability preventing the voter from attending the polling place. The election process in New Hampshire is a relatively simple one. The massive federal legislation contemplated by Congress will overcomplicate our election system at tremendous financial cost. It would negate traditions and procedures that have served New Hampshire voters well, some for over 200 years. I believe the charts that I have provided, based on facts, are self-explanatory, and why I believe this legislation, H.R. 1, will hurt, or S1, will hurt voter participation in the states, and especially in my state of New Hampshire.
Thank you, Mr. Gardner. Sherilyn
Thank you.
Eiffel is the next witness.
Good morning, Chairman Durbin, Ranking Member Grassley, and members of the committee. My name is Sherilyn Eiffel, and I'm the President and Director Counsel of the NAACP Legal Defense and Educational Fund, or LDF. Thank you for the opportunity to testify before you this morning. Since its founding in 1940, LDF has been a leader in the struggle to secure, protect, and advance voting rights for Black voters. We represented Martin Luther King Jr. and the marchers in Selma, Alabama in 1965. We've litigated seminal cases interpreting the scope of the Voting Rights Act over decades, and we continue to litigate on behalf of and work with communities in the South to strengthen and protect the ability of Black citizens to participate in the political process free from discrimination. Beyond litigation, we monitor primary and general elections every year through our nonpartisan Prepared to Vote and Voting Rights Defender initiatives, and we're a founding member of the nonpartisan Civil Rights Election Protection Hotline, which is now administered by the Lawyers Committee for Civil Rights Under Law. Last year, we partnered with LeBron James and the More Than a Vote initiative to recruit young poll workers for the 2020 election to ensure that polling places could remain open in Black communities despite the COVID-19 pandemic, and over 40,000 new poll workers were recruited as a part of that effort. Our experience last year, outlined in detail in my submitted written testimony, makes clear that contrary to numerous news reports, the 2020 election did not go smoothly. Instead, voters overcame a litany of barriers and obstacles with determination and resilience to produce the highest turnout ever recorded in a presidential election. And voters did so during a nationwide pandemic. Throughout the spring and summer of 2020, LDF was involved in numerous lawsuits and other efforts challenging the lack of safe and accessible voting options for Black and medically vulnerable voters during the COVID-19 pandemic in Texas, Louisiana, Alabama, and South Carolina. Our lawsuits resulted in changes in mail-in voting requirements, identification policies, and curbside voting access, significantly increasing voter protections and accessibility. Nevertheless, voters stood for hours on long lines to cast a ballot during the primary and general elections, up to 9 hours in some instances. Their determination was extraordinary. One elderly African-American woman who fainted while waiting hours online to vote in the general election in Alabama refused to get into an ambulance, insisting that she would stay and cast her ballot. Polling place closures and consolidations created confusion for voters. Robocalls targeting Black and Latino voters in Flint, Michigan, and Detroit encouraged voters to vote on Wednesday rather than the Tuesday, November 3rd election. The Civil Rights Election Protection Hotline received over 30,000 calls from voters facing obstacles to voting in the general election. And in one of the most disturbing features of the 2020 election, voter intimidation at levels not seen for decades became an alarming feature. For example, during early voting, numerous Floridians received emails threatening that the Proud Boys, an extremist far-right group, would come after voters who did not cast their ballots for the Republican presidential candidate. And the efforts at voter suppression continued even after Election Day, stoked and encouraged by the former president. People across the country in Michigan, Arizona, Pennsylvania, and more participated in a campaign to disrupt the counting and certification of ballots cast in those states. The violent attack on the Capitol on January 6th was the result of concerted efforts to undermine faith in the election and to overturn its results. And since January 7th, state lawmakers in dozens of states have unleashed a wave of restrictive voter laws. According to the Brennan Center, as of March 24th, state legislators have introduced 361 bills with restrictive provisions in 47 states. Georgia enacted a law which, among other restrictive provisions, criminalizes the provision of water to voters standing online. Arkansas and Florida are following suit. A bill in South Carolina would effectively prohibit the Souls to the Polls voter participation effort favored by Black churches by outlawing early voting on Sundays. Litigation is the principal tool we've had available to us to challenge discriminatory voter suppression laws and practices since the Supreme Court ended the preclearance provision of the Voting Rights Act in the Shelby County versus Holder case in 2013. But litigation cannot fully meet the challenge we're facing. It is slow and it is expensive. The average length of Section 2 cases is 2 to 5 years, during which thousands, if not millions of voters are effectively disenfranchised. This is not a model that can be sustained in a healthy democracy. We need Congress to act. The framers of the 14th and 15th Amendments gave Congress the explicit power to enforce the guarantee of equal protection and the protection against voting discrimination based on race. For 100 years, after the ratification of those amendments, until the passage of the Voting Rights Act in 1965, Congress abdicated its obligation to use this enforcement power as Black people were systematically disenfranchised by poll taxes, literacy tests, understanding clauses. Now Congress must once again use this power to fulfill the promise of full citizenship guaranteed to Black Americans by the Civil War amendments to our Constitution. My full testimony has been submitted and it provides greater detail and source material that I hope will aid the committee in its deliberations. Thank you.
Thank you very much, Ms. Eiffel. And now we have President Jan Jones.
Thank you, Chairman Durbin, Ranking Member Grassley, and distinguished members of the Senate Judiciary Committee for inviting me to testify before today's committee hearing. I come before you as a proud Georgian and member of the Georgia General Assembly, where I serve as Speaker Pro Tem of the Georgia House of Representatives. In Georgia, we're making it easier to vote and harder to cheat. We're ensuring voter accessibility, transparency, and integrity. In 2021, we held both primary and general elections utilizing a new statewide election system during the first modern worldwide pandemic and with record turnout. All these together, along with changes in voter preferences and choices, stressed our election system. Our obligation was to initiate a comprehensive review to assure our state citizens have the ability to vote easily, in a timely manner, and with confidence. But strengthening Georgia's elections processes is not new to 2021. In fact, from 2003 to 2020, since Republicans have had control, 59 elections-related bills were signed into law, including at least one bill each of every year. 2019 legislation addressed concerns primarily expressed by Democrats after the 2018 general election, including a process for curing provisional ballots and lengthening the period to 9 years before some inactive voters are removed from the rolls. Senate Bill 202 is a forward-facing approach to elections, implementing measures to increase voter accessibility and fairness. So please allow me to break down some of the key components. For the very first time, election superintendents shall continue processing, counting, and tabulating ballots until such activities are completed on Election Day to prevent the untimely release of returns. It makes clear that the business of elections is to be run and funded by the government, not tech billionaires and their partisan allies. Again, for the first time, Georgia law now requires 2 Saturdays instead of 1 and 2 optional Sundays of early voting. Senate Bill 202 creates more uniformity of days and hours of early voting in all 159 counties. Now, 134 of Georgia's 159 counties will offer more in-person voting hours than ever before. I would note Georgia's total amount of 17 to 19 days of early voting is more than Delaware, the District of Columbia, New Mexico, Hawaii, Massachusetts, New York, Oregon, and Wisconsin. For the first time, start and end dates for absentee ballot applications will more logically coincide with in-person early voting and practices in other states. This change will increase the likelihood that a voter successfully casts an absentee ballot. 90% of absentee ballot requests in 2020 made greater than 10 days before the election were successfully voted. In contrast, only 50% of requests made fewer than 10 days before the election were successfully voted. This provision increases successful voting. Certainly, though, the legislation does not prohibit poll workers from giving water to people in line, and even voters bringing their own food and water along with them, as has been the long practice. In fact, the bill does the opposite. It prohibits offering anything of value within 150 feet of a polling place, except for water offered by election officials. This is because in 2018 and 2020, activists and candidates appearing on the ballot aggressively for the first time passed out water, food, gift cards, some with logos affixed to them, at polling locations while voters stood in line. It's a practice commonly referred to as line warming, and surely violates the spirit of free elections. The fact is that most states have a prohibition of activities considered to be campaigning or electioneering within a protected space, ranging from 30 feet in Virginia to 100 feet in California to 150 feet in Oklahoma. Finally, I would be remiss if I didn't note the entirely selective outrage I have seen over the last few weeks. As Georgia makes our no-excuse absentee voting more secure, states like Connecticut, Delaware, Massachusetts, New Hampshire, and New York, among others, simply don't have any no-excuse absentee voting. The shame is theirs to bear, not Georgia's. We also eliminated subjective signature matching for absentee ballots and ballot applications, as was criticized by Democrats and Republicans in 2020, and replaced it with objective forms of identification. Let me be clear. Georgia did not eliminate no-excuse absentee voting. It's easy to write alarming words and give misleading sound bites that would lead people away from the facts, because the facts simply don't support what many are hearing or seeing about the mainstream sound Georgia elections law, and it's just plain wrong. Members of the committee, I look forward to answering your questions and setting the record straight on how we're making it easier to vote, harder to cheat, and ensuring every legal vote counts. Thank you.
Thank you, Madam Speaker. I'm sorry if I got your title wrong when I introduced you. I think I elevated you to president in that introduction. But thank you very much for your testimony. We now have Stacey Abrams.
Thank you, Chairman Durbin, Ranking Member Grassley, and members of the committee. Today's conversation regarding the John Lewis Voting Rights Advancement Act does occur against the backdrop of a resurgence of Jim Crow-style voter suppression measures sweeping across state legislatures, grounded in the big lie about fraud and insecurity in the 2020 election. As a necessary reminder, post-Reconstruction laws known as Jim Crow that targeted Black voters never explicitly excluded eligible citizens by race. Then, as now, the laws surgically aimed at behaviors to limit access. With hundreds of bills pending, a significant number of the worst attacks on the right to vote are made possible by the Supreme Court's gutting of the Voting Rights Act of 1965 and the 2013 Shelby County v. Holder decision. That decision authorized states and localities with a history of voting discrimination to again impose limits, restrictions, and barriers to participation. The dramatic proliferation of state-level anti-voting laws across the country in 2021 demonstrates the urgent need for Congress to bring the VRA's pre-clearance formula into the modern era, to reinstate federal oversight over discriminatory voting practices, and to strengthen and protect voting rights wherever suppression occurs. Throughout its history, Georgia has been among the worst actors, including malicious prosecution of lawful absentee ballot users in 2010 and intimidation of Black voters by deputy sheriffs in 2015. Under preclearance, the Department of Justice objected to 170 discriminatory voting changes in Georgia at the state and local level. After Shelby removed preclearance, analysis showed that Black voters were 20% more likely than white voters to not vote due to poll closures, including an estimated 54,000 to 85,000 voters being unable to cast ballots in 2018 alone after 214 such poll closures. Had the VRA been in effect, these changes would have been examined by a federal court or the DOJ to determine whether they were discriminatory before being put into effect. Georgia voters are now anticipating the deleterious effects on elections created by Senate Bill 202, which relies on misinformation, falsehoods, and flawed analysis to restrict access for voters, primarily targeting communities of color. With dozens of attacks on voting rights embedded in the law, I will highlight only a few. Voters of color in Georgia were more likely than white voters to vote by mail for the first time in the last 2 election cycles. Suddenly, SB 202 shortens the time period to request or return an absentee ballot application and imposes new restrictive ID requirements that will have an amplified effect on disabled voters, older voters, voters of color, and Black Georgians in particular. Voters of color in Georgia are more likely than white voters to stand in long lines, including the 8-hour debacle that occurred in June 2020. SB 202 criminalizes a volunteer handing a bottle of water or food to voters or their children while in line. Across the country, these state laws target voters of color by restricting access to the ballot for Black, Latino, Asian American and Pacific Islander, and Native American communities. In Texas, Arizona, and Michigan, each are considering laws to restrict voting rights by people of color. When the fundamental right to vote is left to the political ambitions and prejudices of state actors, one who rely on suppression to maintain power, federal intercession stands as the appropriate remedy. Simply put, the John Lewis Voting Rights Advancement Act is essential to the protection of democracy. Protecting voting rights has been a bipartisan endeavor since the enactment of the Voting Rights Act of 1965 and through every subsequent reauthorization. While each of us may likely have a declared party loyalty, our first obligation is to the fundamental standards of democracy, which must be aggressively nonpartisan. Actions taken to restrict access, thwart participation, or discourage engagement are antithetical to our national creed and should be condemned by every patriot. Instead, we must advocate for voting rights, not to ensure the success of a single party or ideology, but to guarantee a vigorous and fair debate amongst Americans of goodwill. It is my profound hope that we will honor the legacy of my late friend, Congressman John Lewis, and the lives of those lost in the fight for a more perfect union by enacting critical legislation into law. I thank you for the opportunity to take part in this important discussion, and I urge you to continue to strengthen our democracy.
Thank you, Ms. Abrams. Let me concede at the outset that Jim Crow at its worst was more violent than the situation we face today. I don't want to recount all of the horrors of that bigotry and racism that occurred in that era. But I think the bottom line question which we are addressing in this hearing is whether there is a design or an intent in legislation that is being considered and passed in many states, including the state of Georgia, to limit or restrict the right to vote of minority populations with the intent of having influence on the outcome of the election. I think that goes without saying. Clearly, there's a difference in the witnesses who appear before the committee. But I'd like to ask Stacey Abrams, for example, the Speaker Pro Tem, Ms. Jones, said earlier that the new Georgia law made it easier to vote in the state. You've recounted a few instances, but can you think of elements in the law that was signed by Governor Kemp which do the opposite?
Well, first is this falsity that's been proposed that this is an expansion of rights. Let's be clear. In the state of Georgia, 60% of Georgians live in counties that already had, for example, 2 Saturdays of early voting. What has changed is that now additional counties will join the ranks, and that is a good thing. But at the same time that those counties will join those ranks, they have reduced mandatory dates. They have eliminated weeks of early voting during federal runoffs. And let's be very clear that federal runoffs in Georgia were predicated on a racist premise of eliminating access to the right to vote for African Americans. And they eliminate access to a mandatory weekend voting day. Another example is the falsity that this expands hours for voting. Yes, it codifies that you can vote between 9 to 5 as business hours, but for 78% of Georgians, prior to this bill, the hours for voting during early voting was 7 a.m. to 7 p.m. So this actually eliminates hours of voting and mandates only a shortened period of time. That was the misunderstanding that I think is still misunderstood by the Washington Post, because early voting hours that exceed that are now optional and not mandatory. We have 78% of Georgians who would experience longer voting hours and now will see shortened hours. In addition, there is a narrative that says that the use of a Social Security number is allowed for returning your absentee ballot if you do not have access to the ID. Well, let's be clear. You cannot apply for an absentee ballot with your Social Security number. You must have some forms of identification that are unavailable to currently 200,000 Georgians. Those are just a few of the issues. And I will certainly address the criminalization of the handing of water. We have to be clear that in the state of Georgia, 8-hour lines for communities of color has become not an unusual circumstance. Usually we've seen between 4 and 8-hour lines. People do not often come prepared to stand in line for the whole of a business day. They certainly don't often bring their food with them, and this ignores the fact that the overworked poll workers who are inside those buildings do not have the time to come out and hand out refreshments since they are busy processing so many voters who have been underserved. And so I would use those as a few examples of why this bill is deleterious in its effect and malicious in its intent.
Ms. Jones, I would like to ask you to respond to this question. There was an allegation made by the former President of the United States relating to the voting in the state of Georgia. He went so far at one point in the recorded conversation to say that 5,000 dead people had voted. Mr. Raffensperger replied that there were only 2 that they could find, and that was 2 too many. But I would like to ask you if you would comment on the 2020 election. Do you believe there was voter fraud in Georgia, as President Trump alleged?
You know, I'm here to discuss what's in Senate Bill 202, not relitigate the 2018 election in which my former colleague Stacey Abrams never conceded, nor am I here to relitigate the 2020. What I can say is that the bill does increase accessibility. 47 counties had no 2 Saturdays of voting and will be required to now under this bill. Additionally, not one single Georgian will have reduced hours of voting and early voting because it allows up to 7 a.m. to 7 p.m. But what it does do is mandate from 9 in the morning to 5 p.m. and we had 134 counties with less or fewer voting hours for early voting.
Ms. Jones,
the bill absolutely does increase the amount.
If I could follow through on that, the reason for my question is this. I'm trying to understand the logic behind new voting laws, which would give less time to request absentee ballots, strict new ID requirements for absentee ballots, illegal for election officials to mail out absentee ballot applications and the like. In light of the 2020 election, I believe Mr. Raffensperger spoke the truth, and there certainly was no evidence to suggest otherwise when he suggested that the election in 2020 following the old law was absent any major voting fraud and should not be questioned in terms of results. So if the premise was 2020 was sound, why the changes that restricted certain practices that created opportunities for people to vote in Georgia?
Thank you, Chairman Durbin, for the question. Since 2003, 59 elections bills have been passed by the Georgia General Assembly, at least one each of every year. After the 2018 elections, we had an elections bill that addressed some of the concerns expressed by Democrats. In this bill, after a worldwide pandemic, record turnout, a new election system, once again, we're coming back to address concerns expressed by both Democrats and Republicans. The bill absolutely will reduce the long lines, and it will make clear that there has to be proper notice so that voters can know if a precinct is changed. It has to require notice at the old precinct location with a 4-foot by 4-foot sign, also at the new location. There are many provisions in it, but let me just mention specifically with regard to your question about shortening absentee days to request an absentee ballot. As recommended by the Association of County Commissioners, which is a bipartisan group, and the U.S. Postal Service, our timing to request an absentee ballot allowed someone to request one the Friday before the regular election, which almost certainly meant they would have an unsuccessful vote. And so this moves it back to 10 days, which is more expansive, I will admit, 11 days than what the U.S. Postal Service recommended, which was 14 days. But it, I do believe, will result in more successful absentee ballots cast, regardless of whether one lives anywhere in the state and whether they're a Democrat or a Republican.
I'd just say in conclusion that giving Georgia voters under the new law less time to request absentee ballots and shutting down the number of drop boxes from 94 to 23 cannot make it easier to vote or create more opportunity. I think just the opposite is the case. Senator Grassley?
No, I don't know what you're talking about. Speaker Jones, did you look at any other states for guidance or inspiration in the provisions of SB 202?
Yes, sir, we most certainly did. We wanted to make sure that although our voting system is more expansive than many in the country, particularly in the Northeast, we wanted to make sure that any changes we made were mainstream, common sense, and made it easier, more fair, more transparent, and secure for a voter, regardless of their geography or whichever party they tended to vote for. And I do believe this bill does that. We, unlike, frankly, most states in the union, we do have a voter ID, which is common sense regulation and required to pick up a child from daycare, board a flight to go visit grandmother. It's to cash a check. And I think the bigger issue for the 3% who do not currently have either driver's license or a free, and I emphasize free voter ID, I'm most concerned about their ability to participate in the 21st modern century and society as a whole. And that's perhaps where we should give our efforts to, is not undermine the security of elections for absentee ballots, but rather help the few that don't have one to obtain one. Thank you, sir.
Yeah, also to you, Speaker Jones, can you tell me what SB 202 does to reduce lines at vote? And if it's got 10 examples that you can give me just one or two.
Yes, sir. Thank you. Because particularly in the June primary, when we had a brand new election system, elections officials, poll workers were learning how to utilize the machines. We did have some long lines in some areas of the state. They were primarily in counties that are Democrat run. But regardless of that, what we did was we have required that at any single point in time in the next general election, if there is a line of 1 hour or longer, at the next following subsequent general election, the election superintendent for that county must either split the precinct add poll workers, add machines, or all of the three?
I'd like to ask Secretary Gardner, Iowa and New Hampshire brag about first in the nation, one for caucus, one for primary. In fact, H.R. 1, or its state equivalent, S1, is passed. If so, what effect do you think that would have on the ability of our states to preserve their first in the nation status?
Senator, S1 would not specifically have an effect. However, I've made the statement that it could put the New Hampshire primary in a perilous position, and I stand by that statement.
Okay. Let me ask you one other question. Your state has voting laws that are seen as restrictive, yet as you told us in your opening statement, it's consistent that consistently has some of the highest turnout elections in the country. Would you agree with me that voters tend to turn out more for elections when they have more confidence that their vote will be counted appropriately? And what effect has your voter ID provision had on turnout?
Absolutely. The trust and confidence voters have in the process is a huge boost to turnout. And New Hampshire had a voter ID law for the first in the 2012 presidential election. And so 2020, 6 months ago, that was the third presidential election that we had voter ID. We had, in 2012, the highest turnout since 1960 in New Hampshire, over 14% higher than the country as a whole, and higher than we had had in over a half a century among our own presidential elections. In 2012, in 2016, we even went higher than that, 14.5% higher than the country as a whole, with the second presidential election using voter ID. And 2020, it was the same. When voter ID was going through the legislature, there were people saying that 10% of the population was not going to be able to vote. This would hurt certain groups more than it would hurt other groups. And there were polls that nonprofits like Pew published and came and testified in our hearings saying that it could be 11% decline. And in our state, it was just the absolute opposite. As I said, 3 presidential elections in a row, averaging, you have to go back a half a century. So those are the facts on that issue in New Hampshire.
Thank you, Mr. Gardner. Senator Whitehouse, remote.
As you know, I am inclined to ask why about things, and I can't help but wonder why, after the Trump administration top election security official and Georgia's own election officials vouched for the integrity of the last elections, did seemingly every Republican-controlled legislative body in the country pivot, as if on command, to file and move voter suppression bills, 361 of them by one count. When you see group behavior, it's often interesting to look for the motivation. Well, you have the big lie that the election was stolen, which allows for skepticism to be brought against elections, even if it's not founded in fact. And at the same time, you have unpopular policies demanded by a Republican donor elite that has every interest in building an electorate that will give the donor elite its policies rather than giving up on their policies in order to attract voters. As our friend Reverend Warnock says, limiting voters serves this, particularly when limiting voters is to make sure that some people aren't voting. And of course, dark money is that donor elite's weapon of choice. And we see that conservative dark money groups have already announced $39 million in spending campaigns to restrict voting rights at the state level and block passage of the For the People Act. And that number is likely going up because these very same groups spent over $100 million in dark money during just the 2018 election cycle. At the state level, we see two particular groups very prominent. One, the State Policy Network, and two, the American Legislative Exchange Council, the so-called ALEC. ALEC is toxic enough that Exxon severed its ties to ALEC. When ExxonMobil thinks it needs to clean up its act by severing from you, that's a pretty strong signal. So ALEC has singled out Representative Jones for praise, calling her an ALEC legislator. ALEC is funded by Koch Industries. It has received millions of dollars from right-wing foundations like the Charles G. Koch Charitable Foundation, the Searle Freedom Trust, the Bradley Foundation, and also through the Identity Laundering Donors Trust and Donors Capital Fund. It's working now with the Heritage Foundation on a $24 million campaign to produce model voting legislation for state legislatures like Georgia's to adopt, and even to hire lobbyists in what they call crucial states. ALEC has created a secret working group on election-related matters led by Cleta Mitchell, who many people will remember for her role backing Trump's efforts to flip Georgia's election results. So ALEC has its hands all over this. There's also the Georgia Public Policy Center, which is the local affiliate of the State Policy Network. Representative Jones has said, I want to publicly say how much I appreciate Georgia Public Policy Foundation. We rely on Georgia Public Policy Foundation's research and work. They've been an invaluable resource to us. Well, guess what? ALEC is an official associate organization of the State Policy Network with the Georgia Public Policy Center. And the overgroup, the SPN, State Policy Network, has paid for dozens of its think tanks to become ALEC members. So there's a lot of back and forth between the dark money ALEC group and the dark money State Policy Network. Like ALEC, State Policy Network is largely funded by big corporations and right-wing family foundations, including the Koch brothers, the Waltons, the Bradley Foundation, the Roe Foundation, the Coors family, and of course, the ubiquitous identity launderers, Donors Trust, and Donors Capital Fund. There are lots of other familiar names moving into this space. The Heritage Foundation, the Koch-funded dark money groups, political arm, Heritage Action for America, announced plans to spend $24 million on a 2-year effort to shape